Okay, can I go on, sir?
All right. So, good morning, good afternoon, good evening from wherever you are joining us from. My name is Nanchang Nambo.
Yes, sir. And my name is Rebecca Kuwatsuku. I'm your facilitator for today. So can I go on, sir?
Going in to discuss peaceful landlords
Mm.
and tenants.
Okay. Can I proceed, sir?
State as well as a full member of the institute. So please pay attention. Questions will be entertained at the end of the class. I believe.
Yes. Okay, so my name is Rebecca Kuwatsuku. I'm your facilitator for today. And this event is all about sensitizing you about mediation and alternative dispute
And
resolution.
friends to join.
In,
Invite your family and friends to join because it's actually very important. This landlord and tenants issue has been something very critical. So please, your worship, you
yes.
introduce yourself and then proceed accordingly. Thank you.
Okay, sir. So once again, my name is Rebecca Kuwatsuku. I'm your facilitator for today, and the program is about sensitizing you on peaceful resolution in relation to landlord and tenant disputes. And by the end of this program, you find out that mediation works in other aspects too, not only in landlord and tenant matter. So I welcome you here on behalf of Settlement House ADR Training Institute, Shati. The purpose of this program is designed to help landlords, tenants, estate managers, all those agents that take you all around to look for houses, community leaders, youth representatives, and citizens, because it's either you are a tenant or you're a landlord. So this program is beneficial to everyone. So what is this ADR that we are talking about? What is the ADR we are talking about? So I'll give you a brief overview of ADR and mediation. ADR is an acronym for Alternative Dispute Resolution, or sometimes I like to call it, and other people like to call it, appropriate dispute resolution. What disputes is when you have issues, you have joint issues with someone. There is a matter, and then from discussing it, and then you people could not find a solution to it, is a dispute. So landlord and tenancy issues and tenant matter is actually the disputes we are actually going to handle today in relation to ADR and mediation. So mediation on its own is a voluntary and confidential process in which a third party, who is a neutral person called the mediator, helps disputing parties, helps, for example, Rebecca and Mr. John to solve their problems instead of taking it to the courts. The mediator, let's call him Mr. Musa, is the one that will be the third party neutral to walk Rebecca and Mr. John to solve their problems. Now, Rebecca and Mr. John are actually the ones that are going to resolve the matter themselves through communication, finding ways to resolve the matter. The mediator, Mr. Musa, is not going to impose anything on them. He's not going to say, this is how you should resolve this matter, this is how it should be done, but he will just facilitate, guide them through the process. That's what mediation does. So common causes, like I said, we are going to use landlord and tenants disputes to actually talk about mediation as an ADR form of resolving disputes. Common causes of landlord and tenants disputes that we see in the courts are due to non-payment of rents, illegal eviction, property damage, poor communication, rent increment disputes, importance of then not lack of written agreements. So when it comes to non-payment of rents in the courts and legal practitioners, they see landlords suing tenants for not paying their rents as at when due, or the landlord illegally evicting a tenant without taking the tenants to court first, or actually approaching a mediator or an ADR center to resolve the matter. And when it gets to court, when it's illegal eviction and it gets to court, before you know it, a tenant can start saying the landlord stole this, he picked this, he carried this. So from a little civil matter, it can become escalate to a criminal matter. Then landlord and tenants issues happen also due to poor communication, because most times there's an agent in between. And usually some tenants don't even know their landlords. So the agent is actually the king of everything. So he communicates to the landlord about what is going on, and sometimes they don't communicate what is the real situation on ground. So before you see it, you've been taken to court. And then lack of tenancy agreements. We see that a lot in court. There's no tenancy agreement, and the tenant cannot even remember when he paid the rent, when his rent started, when it's to expire. He does not know that one. So when issues relating to landlord and tenant disputes arises, these issues regarding non-payment of rent, illegal eviction, property damage, when, for example, you enter the house and then you install your own wardrobe, and when you were coming, you were going, leaving the property, you decide to remove the wardrobe, and then the landlord claims it spoiled the wall of his house, the structure. So it's also an issue. When there is rent increments, there was no notice to that. Your rent was 100,000. Then before you know it, they are telling you should pay 250, you should pay 200. So when those issues arises, most times people rush to the courts. And litigation on its own has its advantage, but in cases like landlord and tenant disputes and some other civil cause of action, and even some simple offenses, mediation, ADR, works better. So why are we saying ADR, mediation, ADR works better? It saves time and money. Now, when you take the matter to court, you pay filing fees, you do this, you do that, you pay a lot of money, and sometimes you have to engage a lawyer. For the lawyers here, we are not trying to put you out of business. The essence here is to find a faster and efficient way to resolve disputes. So the essence of ADR is not to put lawyers out of business. Lawyers also key into ADR. Everybody can key into ADR and mediation. So mediation to resolve issues emanating from landlord and tenant relationships saves time and money. When you take the matter to court, the date will be fixed. And on that day, something can happen. You might have something to do, and then when it comes to cases, there will be adjournments here and there. If you seek the services of a lawyer, the lawyer has to check his diary. He will have a lot of cases. It's not only your cases, and you are trying to you are trying for the matter to be resolved quickly. But then your lawyer has a lot of cases, and even if the court is free, they will say they want 3 weeks time, 4 weeks time, because they have so issues. So mediation helps because you will actually talk about the time that is convenient for both parties. Mediation also encourages open communication. In courts, you can't just open your mouth to talk. There are times that it will be granted to you to talk. And in cross-examination, there's something we call cross-examination for those that are not lawyers here. When you give your evidence, In cross-examination, you can only answer yes or no questions. You want to buttress, you want to add more points, you want to say more things about your issue. But at that point, you are restricted to a closed question where you can answer yes or no. But in mediation, you can speak freely. There is a lot of time for you to say what is wrong with you, what is disturbing you people. In fact, there are times in mediation that the mediator can decide that you should go into a caucus meeting, a private session. You will be heard separately, the other party will be heard separately, and what you say there will be confidential, except you agree that the mediator discloses to the other party during the joint session. So in mediation, there's a joint session, there's a private session. There's just privacy. No one will hear what is happening. In the courts, we operate an open court system. It's one of the principles of the rule of law that cases in court must be heard in open courts. Anyone can walk into the court and hear your matter. And you might be a private person. You don't want people to hear that you could not pay your rent and they dragged you to court. So mediation provides that opportunity for your case to be resolved in confidence, privately. And for litigation, even if you take your matter to court, this landlord and tenant matter, it will be reported. If you Google about reported tenancy matters, you see many Nigerian law reports reporting cases that have the names of people. There's no anonymous. Your names will be reported. Your matter will be reported. In fact, the courts use reported cases to actually write their judgments to resolve disputes. But in mediation, no one is going to report your case. No one is going to report that Mr. Norms is here. No one is going to report that Norms and Queen, they are all participants here. No one is going to report that Norms could not pay his landlady, Queen, her rent in the sum of 200,000. No one will know. It is a confidential process. Then there is reduction in hostility. Lawyers want to prove to their clients that they are doing a good job, they are doing a very good, they are holding their brief well. So by the time you take issues like this that can be resolved out of court, you take it to the court, the lawyer will stand up and start saying, I put it to you that this is it, this is that. I put it to you that that your rent was expiring, but you refuse to pay, and you are just trying to make your landlord suffer. I put it to you. Before you know it, tempers will be high. People will start. There's no hostility in mediation. It promotes it, and it also promotes lasting peace. After your case is heard in courts, cases like this, simple civil matters like this, are you sure that the relationship between you and the tenants will actually be peaceful? What if the judge decides that the tenant's tenancy has not expired and he should continue staying in the house, and already there was a battle in court between you and your landlord? Will you have peace? They will still be finding ways. You will not have peaceful possession of that premises. You won't have. And when we say landlord and tenants, it's not only landlord and tenant issues that arises in a case. Sometimes even in houses where there are other tenants, disputes can arise even within the tenants. So what we are saying here is there are cases like landlord and tenancy issues, landlord and tenant matters, simple monetary, small monetary claims, family issues, um, other civil matters, a lot of civil matters, and even some simple criminal offenses, not major ones, not capital offenses, not felonies. Simple, even some criminal offenses can be resolved out of courts. It can be resolved. The two holy books, the Quran and the Bible, if you check, they have encouraged people to even try to resolve their disputes before taking it to courts. So now we've been talking about ADR and mediation. Where is your go-to when you actually want to submit your case for mediation for ADR? And there are other ADR methods to resolve disputes. We have negotiation, we have conciliation, we have arbitration. But why we are keen on mediation here is that it's actually more flexible, because the parties would at there's party autonomy, they will take ownership of the process. So where are you going to? Where is your go-to when you have a matter, a dispute, and you don't want litigation, you don't want to take it to courts, you want to submit yourself to mediation, to ADR? We have institutions like the Settlement House ADR Training Institutes, that is Shati. And I'm also part of this beautiful institute that is dedicated to promote peace and effective dispute resolution through education and training, and providing professional services on ADR. Now, one of the aims of this institute is to teach people alternative dispute resolution, because we believe in Shati that when you educate people and teach people how to resolve disputes, then when they also have a dispute, when they have a matter, they themselves can even handle their own matters themselves. If you cast your mind back, or if you check within yourself, we are all mediators, because there are instances where even in your family you have mediated between your father and mother, between your father and siblings, between your siblings, between your neighbors. We have all once in a while, or once or twice, mediated when people around us, when neighbors are at loggerheads and they want to fight. We have once in a while tried to douse the tension. So we have this ADR institute to help us do it professionally, because it's one thing to mediate unprofessionally and it's one thing to mediate professionally. When you don't have the knowledge about ADR, about mediation, you might resolve disputes, help parties, but how is it going to last? You must tie all loose ends. So in Shati, in the institute, you will be trained on how to resolve disputes professionally. You'll be taught about the rudiments of mediation, mediation agreements, mediation clause, how you as a mediation should conduct yourself, how you are to facilitate the process, how you are going to move parties to actually reach a mutual agreement that parties themselves agreed on their own, how you are going to actually lead parties to even arrive at terms of settlement. Because when you, that is not trained, decide to mediate, you just mediate and say, sorry, yeah, hakuri, like what we do, and then go. But for mediation and this ADR institute, a settlement, it is good that a settlement, terms of settlement should be reached at the end of the day. It is neater and better that way. When terms of settlements are reached and agreed upon, parties will sign and it can be enforced. Now, when let me give you an example of a case that happened before me. Though I'm a magistrate, a district court judge, I still move parties. It is still my duty to encourage parties to mediate, to submit themselves to mediation and ADR. There's this case I had. A landlord sued his tenants, and the tenant, in fact, has hearing problems. So I had to shout and strain. I had to shout a lot so that the man will hear. The man that has hearing issues. So I told the landlord, and the landlord was telling me he has a training, he has to travel to Lagos, he has this. I said, see, since you don't even have time for your matter to be heard, I think you should submit yourself to mediation. And the tenant, the defendant, has problem with hearing. Mediation is a closed process. You'll be close to the mediator instead of the judge being on a high bench and you'll be a bit afar off from the judge. I know sometimes in our courtrooms, most times, we don't have all these devices, hearing aids, recording devices that will even help. So I said they should submit. They were still dragging, and thank God the lawyer that is representing the landlord is also someone that is keen towards mediation and ADR. So I told them, I realized that the issue joined is that the landlord, the crux of the matter is why he brought the tenants to court is because he did not see 2 years rent. So the defendant is saying, I paid the rent. Then where is the evidence? When he paid the rent, he did not speak to the landlord and say, see, I've paid the rent. This is the evidence that I paid you rent. And you know, in law, the burden of proving payment of rent is on the tenants. You are the one that paid rent. You are the one that should demand for evidence of payment of rent. Because if your landlord takes you to court for non-payment of rent, you are the one to prove that you paid rent. It's just like when you go to buy a TV in the market, you should collect a receipt. If you don't collect receipt and at the gate they start shouting, thief, thief, there's a thief that stole a TV, and they said it is this TV, and you said you just bought it, they ask you for receipts and you don't have, it will be a problem. You must have a document to show that you actually paid for things and you pay for rent. So the issue here is that he did not, when he paid rent, he did not call the landlord and he was not issued a receipt. So I asked him, do you have, can you check your bank statements? Can you just go back and check your bank statements? Let's see whether there's something there to show you paid the rent. He said he paid through POS. So there are Nigerians that pay their rent through POS. Now, if you pay through POS, you are supposed to confirm whether it's the agent that you are supposed to confirm with or the landlord. You ask whether you pay that rent. But he did not. He paid through POS and he has nothing to show. So thank God he paid through the account of the landlord. So I told the landlord, see, since the issue is on payment of rent and he's saying he paid, I think you should just go and check with your bank to see. You check your statement of account to see whether there's this money that is unaccounted for. I now give them a date as for report of settlements. I said they should start, they should subject themselves to out of court settlements. So both of them were actually the landlord, the lawyer to the landlord, since he's a retired judiciary staff and he has not spent his years practicing as a lawyer. So he's actually he supported the mediation. He told the parties that they should actually take my advice. So they went to check, and on the next adjourned date, I said, okay, how far? What is the situation now? Did you actually confirm that he paid rent? He said yes. He noticed that in the last 2 years, there were he received two alerts, credit alerts, as to so amounts. And no one called him to say that they sent that money, and it's the amounts the tenant spoke about. So, but he's saying that since he's also seeking for recovery of premises, and he has found out that the man has even paid for this year's rent, and the rent is supposed to expire, tenancy is supposed to expire August, and they still want the defendant out. The defendant said yes, that he wants to be, he's not disputing recovery of premises, but he wants his time to end before he leaves. And they entered an agreement. They drafted it and they filed it, and it was accepted as consent judgment. So what we are trying to say in essence is mediation works. They would have spent time, I'm sure by now, would have still been on trial, hearing both sides. So these are one of the numerous benefits of mediation. So this is time for you to ask your questions and answers. I'm expecting questions on how you will join Shati, how you will join us, how you get educated on ADR, how you get knowledge about it, how you be certified too, so that you can actually be qualified as a mediator. Because you don't need to actually be a lawyer. Anyone can be a mediator as long as you are trained. One of the qualification is not being a lawyer. You don't have to go to law school and be called to bar to be a mediator. You don't have to be that. So, but for litigation, a qualified lawyer, someone called to the Nigerian bar must be the one to represent. So, any questions for us? Any questions? if you have a question, can you unmute yourself and ask the question?
Good evening, ma.
Good evening.
And
Can
thank
I
you
hear
for
you?
that. Okay, my name is Martha Timothy Bulus,
Yes, ma'am.
and I really appreciate your lecture sensitization this evening. Please, I want to ask,
Yes.
you are encouraging us to go into mediation, to
Yes.
choose mediation over litigation and all that.
Yes.
My question is, this mediation, you talked about um,
Mrs. Mata, I'm not hearing you.
after, just this. So I just want to ask it as a lay. Okay, I know. Can you hear me now?
Yes, I'm hearing you now.
Can you hear me now?
I can hear you now.
Okay, I said, okay, I'm a lay person. I want to ask this question as a lay person.
Yes.
Someone just heard about mediation. So
Yes.
when, supposing I agree to submit to mediation,
Yes.
after everything, you did mention that we would come to agreement, terms of agreement, and all that. My
Yes.
question is, terms of agreement, are they enforceable? Because we're in Nigeria,
Yes.
some people only believe in God. It's only the judge or whosoever can force them to accept, conditions of agreement or something. So, does mediation really work like that in Nigeria? Are the terms of agreement, are they enforceable? Thank you,
Yes,
ma.
madam. In terms of settlement in mediation are very enforceable because number one, mediation is a voluntary process which parties subjected themselves into. They were not forced into it because they must have already signed and agreed to subject themselves to mediation. So whatever comes out of that mediation, like the terms of settlement, parties will be run through they will be run through the terms of settlement. Parties must understand that these are the terms, and they must understand that the terms are binding on them. So it is enforceable. And once you have signed a terms of agreement, anything you have signed, even out of mediation, if you sign that you are going to sell your house to someone and you collected money for it, is enforceable against you. So when you sign your terms of settlement, you append your name, your signature, you accept that it has been read to you, like let's say if it was written in, and terms of mediation can be written in any language that parties understand. If it's Hausa you understand, it can be written in Hausa and it can be translated in English. Now it can be enforced in courts. It can be enforced because once you sign the terms of settlement, it has become your own agreement. It has become your own judgment. It's like you wrote your own judgment with your own hand. That is the terms of settlement. You wrote it with your own hand. So you wrote your own judgment with your own hand. So it is enforceable. For litigation, when a judge writes judgments, it is enforced. That is even a judge that wrote a decision that you might not even be happy with it, you are not, it's not favorable to you, but it will be enforced against you. Then now we are talking about a decision that you arrived yourself with someone and you signed it, then it is very enforceable. It is a clean agreement and it is enforceable. But most times with mediation, since it is something that parties agree on, most times it does not even get to that point that parties have to be that the terms of agreements will now be taken to court to enforce. Most times we see parties abiding by those terms of settlement because it is their own agreements, it is their own settlements.
Okay, thank you very much, ma.
Thank you so much, ma, for the question. So does anyone have another question?
Okay, good evening, everyone.
Good evening. Is this Queen?
Yes, mine is not a question, it's just to add to what you've said.
Okay.
Last 2 months, I was involved in that settlement, that ADR, with a friend.
Yes.
She gave someone 3 million naira for a business. And
Yes.
I am sure some people don't read agreements when it's handed over to them, they just sign it. So I'm very sure in his case, he didn't even read it. But he stated that if he fails to return the money November last year, he was
Yes.
going to pay for, because it was money borrowed from the bank. So the interest that was accumulated, he was going to pay. He didn't read that part.
Yes.
So when we went to ADR, they were talking, going back and forth, and asked me if he read the agreement that was handed over to him. He was just
Yes.
looking at me. I said, where is the agreement they gave you? He said, it's not with it here. I said, okay, anyway, I'm here with mine. You should take and read. Now, it is written here that if he fails to make a refund in November, this is what will happen. He was really stunned. But just to answer her, he promised to pay the money 20th of last month.
Yes. He promised orally, or there was they actually wrote terms of settlement to that effect.
Yes. So he actually did.
Okay. And he has abided by the terms of settlement?
Ma?
And okay, you said they reached an agreement that he will pay the
Yes,
money.
and he paid the money, yes.
Yes, because it is now his own agreement.
Yes, I'm just trying to tell her that it actually works here in Nigeria.
It does work. Yes, thank you for that. Do we have questions from other participants? Please, this is the time to ask questions because it's a sensitization program. And usually, when things like this are done, people must pay for them before these kind of events or programs happen. So take opportunity, use the time, and ask questions. Do you have more questions?
Yes, good evening.
Yes, good evening. What's your name?
I'm audible.
Yes, you are. What's
Okay,
your
my name
name?
is Pama Katun.
Okay, sir.
It's
Well,
Pama Katun, yeah. So thank you for this sensitization. So I have two questions actually. So
yes,
the
sir.
first one is okay, if after like the two parties have gotten to like a resolution, and eventually one party maybe realizes that he has been shortchanged or something and he wants to appeal. So is there like a provision for appeal so that the terms of resolution can be like maybe reviewed? That is number one. Then number two, you talked about like a how do I put it? This ADR, I think it's like how do I put it? Like a corporate organization, right? For the lack of
Yes.
a better word, it's like maybe like so does that mean that court doesn't recognize like resolutions gotten from ADRs that are not registered, or it has to be registered for a court to recognize it?
To recognize,
Maybe a
you said?
resolution because okay, you mentioned that ADR that okay, very good. You said that like there's an institute, right? There's an
Yes.
institute for ADR or something like that.
We
So
have different.
yes. So does that mean hello?
Hello, I'm hearing you.
Okay, so for the mediator, must the mediator be like a registered member of the institute for him to be recognized by the courts? Or you could just get like maybe someone you feel is a seasoned mediator but is not registered. Can that person be recognized by the court?
Okay, let me start with your first question. The first question is if terms of settlement can be reviewed, right?
Yes.
Okay, so once, let's say you and me have a dispute, and then we submitted ourselves to mediation, and then we arrived
Yes.
at a terms of settlement. No one was forced, it was voluntary, it was mutual. We all appended our signature. So you should understand that a
Yes.
mediator does not dictate the terms of settlements. He doesn't. He will not tell
Okay.
you how to resolve the
Okay.
matter. It is you and the person. So
Okay.
most times there's just no way
Okay.
that at the end of the day you will be shortchanged. Can you shortchange? No. So the mediator doesn't tell you these are the terms of settlement. He doesn't dictate. He just watches. He's a neutral third party. He just facilitates.
Okay.
Yes, he
Okay.
facilitates by telling you, okay, you've entered into mediation. Have you people signed the agreement to mediate? Have you people signed that have you people signed the agreement to mediate? These are the ground rules. We respect ourselves. This one have how many minutes? This one have that minutes. Can I record you in this process? Just
Okay.
basically ground rules, but he is not never going to tell you how to resolve the matter. So you can't, it's difficult to have a situation where you be shortchanged because it is communication. As for example, if the person says he's suing you for 150,000, you say no,
Yes.
it's not 150, it's 100,000. You can't come and sign 150,000 when you've not been agreeing to 100,000, except you decided to willingly agree and the other party agree. The terms of settlement have to be mutually agreed by parties. You can take all the time you want, all the session you want to take, the hours you take. It's and parties will agree to for the session maybe 2 hours daily. So it is at your own convenience. So at the end of the day, it is your own terms of settlement. It is. So it can hardly get to that stage. Now, to answer your question, let's say now you have agreed to a terms of settlement. This is mediation we are talking about. Nobody forced you. And it is now binding on you. And then you want to appeal it. You can't appeal what you have signed on willingly. You cannot, except if the mediation process itself had an issue. You can only appeal on the procedure that matter was arrived at. For example, let's say you speak Hausa. You don't understand English at all. And then mediation was conducted in English. It was conducted in English and you didn't understand
Yes.
everything. And then at the end of the day, the terms of agreement was written in English and you don't understand. And that one will hardly happen. Now, it takes us to your second question. Now, this can happen. Problems arising from mediation can only happen if the mediator is not a seasoned mediator. He is not a qualified mediator. That is when these kind of issues can arise. That is why we are saying we have ADR institutes and centers. We have the Kaduna Multi-Door Courthouse. To answer another part of your question, the court accepts mediation agreements. See, parties can even agree to settle matter and enter agreement without even a mediator to start with. Me and you can have a problem and there won't even be a mediator as long as we agree and draft our terms of settlement. We can, the court will accept it. I've had cases where parties will come unrepresented by a lawyer. Then they will say that they want to settle out of court and we'll give them a day. They will go and draft their terms of settlement by themselves and sign it. The court will accept whatever agreement parties agree to as far as it's a legal agreement, not illegal. An agreement for a legal thing to be done can be signed by parties without any other person involved. As long as parties voluntarily agree to it and come before the court, it can be enforced. So the court will accept an agreement even if we don't a mediator that is not accredited by any ADR institutes actually facilitated the process. No, we have lawyers that facilitate mediation in cases and they are not even recognized by any institute. But this issue that you raised in your first question can happen because they are not qualified and seasoned mediators. It's only a qualified mediator that will be able to facilitate the process in such a way that parties will not come and say they were shortchanged. How can you be shortchanged in an effective mediation that was done, in a mediation that was done effectively? So we have bad mediators. We even have bad mediators. We have effective mediation. We have ineffective mediation. And effective mediation happens when a mediator is qualified. He is seasoned, he is trained by an ADR institute, so he will know his onions. Now, anybody I told you can mediate, but how will they do it? Do you get? How there can be pitfalls, there can be some things that they will leave out because they are not qualified to even do it in the first place. But no one stops them from mediating. Nobody stops you from actually mediating. Unlike arbitration, you must be qualified, you must be a seasoned, you must be qualified, you must be trained. But for mediation, anyone can mediate. But the problem with it, when someone that is not qualified and is not a professional, someone accredited by mediation and ADR training institutes like Settlement House ADR Training Institute does it, this kind of issues can arise because he's not qualified. Now, okay, if there was time, there was time, we could have done a practical and we'll say you should try to mediate a dispute between two parties. And you will find out that even though you have the knowledge on how to actually settle people when they have issues, they will give you so much headache. There will be a lot of gaps. There will be a point that you will be so tired, you won't know the way forward. Because you just felt, you can just say, kuya hakuri, sorry, okay, you agree to do this. You will find out that you are trying to dictate terms to them because you have not been trained. But when I decide to do it, you will see a different procedure. You only see me trying to move parties to actually come to terms, to communicate and discuss, to settle their own problems. So did I answer your question, or is there any area that I missed? Can you hear me? Hello? Can you hear
I'm
me?
audible. I'm audible.
Yes,
I'm
now.
audible. I can hear
Yes.
you. You're audible.
Is
Okay.
there any?
Yeah. Basically, actually, well, yes, sort of, because the line was breaking. That's on my own part. The line was breaking.
Oh
Um,
my.
at a point, the line, I was not really getting what you were saying. So I don't know. Is there like a medium, maybe like a link or I don't know, something like a medium where we can reach out to you after this meeting so that we don't take a lot of time? Because most of the time, while you were explaining, the line was breaking. I couldn't really get what you were saying. So is there a
Okay.
way we can reach you after this program? Yes, that's with additional question. Then secondly, I think
Can
somebody sent his question via chat. So please just kindly go through the chat because the person is at work. So kindly go through the
you,
chat so that you can address that person's question. So thank you and over.
let me check the chats. Okay. In a situation where my case is already in court, can you hear me? Can everyone hear me? In a
Yes,
situation
Yes,
where
we
we
can
hear
hear
you.
your voice.
right, in a situation where my case is already in court, can both parties decide to opt out for ADR? Secondly, if both parties are not satisfied with the settlement terms for ADR, can they still go back to court in order to continue with the case in court? Okay, so to answer of your question, where your case is already in court, where your case is already in court, you can tell the court, you can out of court settlements, like I dispose towards mediation, towards ADR, because the courts are even overstressed with lots of cases. There are many cases that shouldn't even come to court, that shouldn't be in court, like landlord and tenant issues and monetary claims and so on. And many civil matters. Many civil matters shouldn't even be in court in the first place. So your case can even be at any stage, you can tell the court that you are applying for a date so that you can see how you can resolve this matter out of court. And the other party will say, I agree, because you must have discussed that you want to settle out of court. And the court will give you a date for report of settlement or continuation of the case at whatever stage it is. Now, let's say the case was at hearing stage, and then parties decide that they want to settle out of court. On that day, you tell the court, Your worship, my lord, parties are discussing settlements. We please apply for another date so that parties can explore out of court settlements. The court will give you a date to report settlements or to continue hearing. And on the next date, if you have not settled, you've not reached terms of settlement, you can still ask for time to settle the matter. So you can at any stage inform the court. The only time that you can't do that is when the courts have entered their judgments. The court has entered judgments. And when the court enters judgment, the court cannot go back on it and say it should be that you people should go for ADR. Now, on the second part, he said if parties are not satisfied with terms of settlement, can they still go back? If parties are not satisfied with settlement terms for ADR, can they still go back to court in order to continue? Now, this takes us back to the issue. If parties are not satisfied with the terms, now that ADR, that procedure, that process through which parties arrive at the terms, was a mediator involved who facilitated that ADR, that settlement. If a qualified mediator is involved, parties will definitely be satisfied because it is their own terms of settlement. But if the parties decide to settle themselves, they decide to settle themselves, they have to make sure that the terms are actually what they themselves agree to before they sign their signature. When the parties sign their signature to terms of settlement and they file it in court, usually they adopt it and tell the court that this is our terms of settlement and we want the court to enter it as consent judgment. Now, once the court enters consent judgment on your terms of settlement, you cannot even appeal it. It is your own terms. You adopted those terms of settlement, whether you entered it by yourself without a mediator, whether it is a mediator that facilitated it, as long as you enter terms of settlement that parties you yourselves have voluntarily agreed to, and you brought it to court and filed it, the court will enter it as the agreement in this matter, as consent judgment to enter it. And you can't even appeal your own terms of agreement. So before it reaches the courts, if you people are not satisfied with your terms of agreement, then you people, both of you, the parties, can mutually withdraw it. You can mutually terminate it. You can mutually terminate the fresh one. And when you are entering the fresh one, you will state that the earlier terms of settlement have been mutually terminated by parties. You see, everything that has to do with ADR, everything that has to do with mediation has to come by a mutual agreement. Mutual agreement, everything. Even if you enter terms of settlement and sign it, if you people decide that you are not okay with it, it's not enough for you, you are not satisfied with it, you can mutually withdraw it, mutually terminate it, and enter a fresh one, only if both of you agree. But one party cannot on its own, after you people have mutually agreed and enter terms of settlement and signed, one party cannot negate it. One party cannot come back and say, no, I don't like the terms of settlement again. You have appended your signature, you have signed it. You have signed it. So, like I said, it's just like when you buy a TV in the market and you have been issued receipts and you brought it to your house. Can you go back and say, no, I don't want the TV again? I don't want it. I don't want the TV again. You can't say that. But if the seller agrees with you that you can return the TV even after buying and paying for it, You people can actually review that. You can allow, or you pay for something and under that thing it was written no refund, and you say no, me I don't agree, I don't agree to that. When you have signed the document that says you have forfeited that money, there's no refund, you cannot come back and seek for refund when you have signed it. So it is essential in every agreement you enter into that you understand your agreements. That is why we are stressing the point of involving a qualified mediator. This is how you avoid all these pitfalls when a qualified mediator is involved. And if you want to mediate between parties, what we are saying is ensure that you are qualified by institutes like Shati. Make sure you are qualified to actually facilitate in matters involving parties in disputes, so that the outcome will be lasting. The essence of mediation is to give lasting peace. When we have unqualified mediators, there won't be lasting resolution. The essence is for parties to have a lasting resolution so that they will not come back. For litigation, when parties are not satisfied, they keep appealing, but for mediation, when parties enter that agreement mutually and they sign it mutually, you cannot come back and say you are appealing what's your own judgment. It is your own decision. You can't, except there are defects, and those defects only arises if the mediator or the people that facilitated that agreement are not qualified. So did I answer your question? Is there anyone that wants to ask a question? Is there anyone? Is there anyone that wants to ask another question?
Yes, one last
Hello?
question, please.
Yes, sir.
Okay, please, what are the benefits of being an ADR mediator? What are the benefits
Of being a mediator. Yes, I know you will.
an ADR mediator?
Yeah, I know that you are looking at
Yes.
the financial aspects. So mediation, I know that's where you are headed to.
No,
So
no,
even
not
though,
really, not really, because
okay,
okay, go ahead, please.
benefit of being a mediator, okay, of being trained as a mediator, right? That is it. Okay, so first of all, like I said, one of the benefits of you subjecting yourself to be trained as a mediator is you yourself can be able to resolve your own problems, your own disputes. In fact, you even know how to avoid disputes. And sometimes you can't just avoid conflicts, they just come. But as a mediator, you can even resolve your own matter with the person. There's a way you have mediation tips at your own fingertips. You can be able to even resolve your own problems, and you can be able to resolve other people's problems professionally. And mediation, even though we say mediation is cheaper than litigation, it does not mean it's free. As a mediator, you charge your own fees. That's why in the agreement to mediate, your charge it's all included. Now, these questions that you are asking me, these are questions that will be taught to you, that you will be trained on. These are questions that will be answered when you subject yourself to be trained as a mediator, when you register to be trained as a mediator. All these your questions will be answered. You will be trained as a mediator. You will see the benefits to you personally as a person, the benefits to your own community. You can resolve neighborhood disputes, communal disputes. You can resolve problems in your family. You can resolve problems in the church. You can resolve problems in the mosque. You can resolve issues everywhere, even your own. And then you get, as you do it, you get you become more knowledgeable in mediation. And then there's the financial aspect, and then it gives lasting peace. If your neighbors are sleeping well, you also sleep well. When your neighbors are fighting today, when, for example, houses that the landlord and the tenants are staying together and they start fighting, and you are a qualified mediator, before you know it, you want to settle them so that you have a good sleep. You even advise people to take their matter, to resolve their matter through mediation. You will also be an ambassador, an advocate of ADR, an ambassador of peace, because mediation is all about lasting peace. So everywhere you go, your mind will be tuned to how can these issues be resolved peacefully without any hostility. So these are the benefits. You will know about more benefits when you subject yourself to be trained as a mediator. So any more
Okay,
question?
thank you so much. So basically, I'm going to be an elder, basically.
Yes. Yes.
Okay, thank
Okay,
you
good
so much.
evening.
Thank you for the engagement. Good evening.
Okay, this is non-biggie Abila.
Yes, sir.
Uh, I'll really say I'm very much impressed with this enlightenment. I
Yes.
believe most of might not have had the opportunity to know some of these things you were saying today, but at least
Yes.
being part of this program, it really
Yes.
has helped. So I want to ask the question this way. Okay,
Yes.
as a certified ADR, yeah,
As a certified
mediator, I mean,
mediator. Yes.
do you, is it that after undergoing the program and being certified, are you
Yes.
given that privilege, or do you have that authority to own your own mediating firm or what?
After you are certified as a mediator,
Yes. Or there are
mm,
other courses you undergo before owning your own corporation, something like that.
there are many courses you should undergo. You have to be qualified, you have to be
Okay.
trained, and you must be able to have the qualification to even train others as mediators. So, like I said, is one step at a time. First, you yourself have to be a professional, accredited, and qualified mediator. Now, the first step to take is by subjecting yourself to a mediation training by a reputable institute. And we have many institutes. Like today, this training is done under the umbrella of the Settlement House ADR Training Institute Shati. I have uploaded the documents, a document. If you check the chats, you can download it. I've uploaded it. It's just the program outline on today's event, on this event, and the various social media handle of Shati Training Institutes is there. It's in the documents. Their social media handles, their email address, their phone numbers. They are all included there. It's there for you to reach out to them so that you can find out how you can go about it. But the very first step is you yourself. Before you can even say you even own your own training institute and an ADR training institute, there are qualifications, lots of qualifications. And at least the first step is actually to be trained as a mediator by a reputable institute. So it's from there that you can pick it up. It's actually from there. So the more the better. No, there's no law that stops you from having your own ADR training institutes, but there are procedures
Okay.
and there are requirements. So the first
No.
requirement is you yourself have to even be a mediator. Yes,
All right.
you have to be
Thank you very much.
qualified. Yes.
All right. Thank you.
Yes, so you can all check. I have, it's just a little piece of document showing the program outline and details about the training institutes. Yes, so any question? Any more question? Any question? Okay, so I'm happy with the engagements. I'm so glad. I thank everyone for joining this program. It was very interesting. It was so interesting. Mr. Nanchang, do you have anything for us? Hello, can you hear me? Barrister Nanchan. Can you all hear me?
Yes, we can hear you.
We can. Yeah.
Yes, we can hear
Okay.
you.
Okay, Barrister Nanchan, please, do you have anything to say before we close? Okay. So I think
I think
it's left.
he has opted out, probably. Yes.
Right. So thank you all for being here. The conversation still continues. If you have anything on the flyer, my number is there on the flyer, and then on the program
Yes,
itself,
we can.
I shared. It's all there. You can reach out and ask questions on how to be a trained mediator.
You have
And
one question in the chat.
yes, there's another question. Okay. What are the benefits of being a certified mediator? No, I have answered that. Okay, how long should an ideal mediation process take? And does the length of time demonstrate mastery of mediation? Now, mediation process, like we said, is in the hands of the parties. It's in the hands of the parties. So mediation, you keep having sessions as it warrants, as settling that dispute warrants. If today, if you say you are going for 5 sessions, and at the end of the day, parties did not arrive at a mutual settlement, you can ask parties whether they want another session. The essence is for the issue to be settled. But what we know for sure about mediation is that disputes are resolved faster than how it is resolved in courts. That's what we know for sure. There is no specific time limit that you say, okay, parties should have resolved their matter around this period of time. No, it is in the hands of parties. So they can decide to be taking it one step at a time, one step at a time. And the way we know Nigerians, the way we know most human beings, we are definitely not so patient to be discussing one thing after the other. The essence is you actually brought yourself so that the matter can be settled, so that the matter can be resolved. And most times, parties are eager to settle. Now, the only time that mediation will take a long time is if parties are not even communicating. And as your role as a qualified mediator is to ensure that parties even speak. You find a way of making parties to talk. If parties are speaking, if you and I have an issue and we start talking about it, you know that we'll resolve it faster. But when we are quiet, nobody wants to talk. That's when it will take more time. So the essence is to ensure that parties speak. They should speak. And that's why in the mediation, some ground rules are set on how to talk to each other, how to respect each other. Mediation doesn't take that time, but you are not to tie parties to a time frame. No, you are not to tie them to a time frame. Remember, you as a mediator, you are just the facilitator. The process is in the hands of the party, is in their hands, party autonomy. So they can decide to today, okay, one sitting. Maybe you people decided on 5 sessions and then they did not arrive at a settlement. They can add and say, okay, we need 2 more sessions. We need 3 more sessions. The essence is for parties to reach a mutually acceptable resolution. So there's no need to rush it. Unlike litigation that the judge might even be tired and might say, don't waste my time. You are wasting my time. But in mediation, it is in your own hands. You take as much time as you need to. You can even take breaks. You can take breaks. You can even go on recess. You can shift it to another day. So, does the length of time demonstrate mastery of mediation? The length of time does not show mastery. It doesn't. You can rush parties to reach an agreement, and at the end of the day, like the question that Mr. Palmer was asking, if mediation is rushed and at the end of the day the settlement did not favor both parties, was proper mediation arrived at. That's why we said we are looking at effective mediation, not just common mediation. So one of the pitfalls to even avoid the mediation is trying to rush it. Length of time does not show mastery. You can rush parties, and then parties will arrive at one settlement, and they will say, no, they were rushing us. The mediator was saying that she has a church meeting to attend. She has to go and pick her kids. She has to do that. So that's, you have to be qualified as a mediator to avoid all these things. You must be patient with parties. You must be patient. That's why there are ground rules. You can say each session per day is 2 hours. Each session per day is 3 hours. Do we agree? Do parties agree that each session should be 2 hours, each session should be 3 hours? And parties can amend and re-amend the rules of that mediation. When it comes to the rules of mediation, it is in the hands of parties too to actually modify and amend it. So the time does not show mastery. As long as at the end of the day, parties arrive at a solution that both parties agree to and they are happy with it, and there's lasting peace. That's what we are following. And mediation in itself does not take so much time. Most times within a month, parties have settled, because the session is not like a court matter that the judge has 10 cases in that day and he's trying to rush you. So the time does not show mastery. But what I will say for sure is that as you do mediation, as a qualified mediator, the more you do the process, the more you facilitate mediation, the more you find little shortcuts, the more you find some techniques that will actually fasten mediation. That's just it. The more you mediate, the more you facilitate mediation, the more you help parties as a mediator to resolve their own issue, the more you become a pro. And all these situations that can drag mediation, by now you would have mastered it. You would have known how to effectively facilitate and drive parties towards resolving their disputes at a very at a time that at a very short time, not short time to say, at the appropriate time. Whether short or long, the time should be appropriate. The time that dispute was resolved was actually, as long as the dispute was resolved appropriately, we don't actually look at the time. But like I said, the more you mediate, you will actually be empowered with all these techniques that we make you be able to move parties to actually resolve their disputes a bit faster. That long time that they will stay and be fighting, and you will be able to navigate them to resolve it a bit faster, so that they won't really waste so much time like that. So that's just what I can say. But really, the time does not really matter. What we are after is for parties to arrive at a mutually agreed settlement, and for lasting peace, and for their relationships to be sustained. So that's it. Any more question? Any more
Good
question?
evening, everyone. Good
Good
evening.
evening.
My name is Mariam Abdul.
Yes,
I'd like to first of all commend you for a very thoughtful explanation on the topic. You did
yes.
extremely well.
Thank you so
I
much.
would just like to add a bit to what you have already explained.
Yes.
One of the questions was asking
Mm.
something about like the relationship between the court and mediation or ADR, how the court accepts, or rather how they
Yeah.
deal with ADR. Yes. So in addition to what you already said, I'd like to add
Yes.
that the courts actually encourage mediation. They encourage you to
Yes.
settle out of court. So
Yes.
at any time, like you said, the court will
Mm.
let you if you ask. And at sometimes you don't even have to ask. If the court feels this court
Yeah.
will best be settled out of court, The court
Yes.
will refer you
Very well.
to mediation, or sometimes they'll just ask you to try and settle. And that settlement for that purpose does not have to be um like if you ask, like the person that asked if his case is in court already, if your case
Yeah.
is in court and you want to go for settlement, at
Yeah.
that period, if you feel you can settle on your own, you can just meet the other person and decide on what you want. When you do
Mm,
that, you just go and inform the court, and the court will take it as consent judgment. And
mm,
then you can also take it, or the court can actually refer you to an ADR center where it will be done by a qualified mediator, a certified mediator. And
yes.
whatever you bring back to court will be entered as consent judgment.
Yeah.
That's that. And then on the issue of the length of time, normally what determines the length of time is the nature of your dispute
Yes.
and the how the parties are taking it. Some parties are very easy to deal with and very easy or accepting on terms. Some
Yes.
will not accept terms, some will not agree, so the nature of the issue actually determines how long your your session or the whole process takes. And
Mm,
yes, you take breaks, you take adjournment, it doesn't
mm,
really matter. The aim
yeah,
always is to make sure that there is peace, that the dispute is resolved based on the parties' agreement.
yes.
Thank you very much.
Yes. Thank you so much, Mariam. And
Thank you.
to add to what she said, mediation, we should know that mediation is actually the process of mediation is guided, or the legal framework for mediation has a legal framework. We have the Arbitration and Mediation Acts 2026. So there is even an act, a law, that guides the process of mediation. So that's how you know that even the society on its own, even Nigeria as a country, supports mediation. There is a law as to mediation, the Arbitration and Mediation Acts. It guides the process of mediation. Then, like she said, even the courts can on its own, like I said, even the courts, we are encouraged to further encourage parties to resolve their matter out of court through ADR, through mediation. A judge can actually refer parties for ADR. They can refer them to Shati, they can refer them to Kaduna Multi-Door Court House inside the High Court, within the High Court Justice. They can refer you to any mediation, reputable, registered mediation ADR center. They can do that. And when a court so orders mediation, ADR, to tell you how the courts are serious with it, you must attempt it. There must be an attempt before the matter is brought back. I have actually referred matters to ADR centers for mediation. And when you refer the matter, you don't tell them that they should mediate within 1 month, they should mediate within 2 months. No, you will refer for mediation. When they have when they have concluded the process of mediation and parties have settled and filed their terms of settlement, the file will be sent back to the courts so that the courts can enforce those terms of settlement. It will be entered as consent judgment and is binding on parties. Now, there are situations like where parties will not even, it's not every mediation process that at the end of the day parties will agree. At the end of the day, parties can withdraw. Like we said, mediation is voluntary. Parties can withdraw at any point in time. When they attempt it, when the court sends them and say they must attempt it, in the process of that mediation, they can withdraw and say, this process does not fit us, so we want to go back to court. The ADR Institute, that center, will send back the file to the court and the case will continue into litigation. Mediation is never by force, it's voluntary. The process is voluntary and you can withdraw at any stage. But like she said, there are times that when you bring a matter under litigation in the court can refer you And if the court requires for mediation, it must be attempted. But the court is not saying it must be resolved through ADR, through mediation or any ADR means. They must attempt it. So the report from the ADR center will show whether the matter was successfully resolved through mediation, through those terms of settlement, or they will say, the matter could not be settled. They will write to the court, and then the matter will proceed into litigation. So, any other question? Any other question? So it was nice being here with you. I appreciate everyone for being here. So we are available, we are open to more questions, more engagement from you, and how we can guide you to actually be trained as mediators. And I'm inviting everyone to the upcoming Kaduna Settlement Week. So you see, Kaduna as a state is pro ADR. Every year we have Settlement Week. This is where there is free mediation. You only give a little token for the case to be filed, for your matter to be filed. And if anyone here has a problem, has a dispute, you can go and file it in the High Court of Justice. You walk into the Kaduna Multi-Door Court House. Let me see if we have the flyer. Let me share the flyer with you here. The Kaduna Multi-Door Court House. If you have any disputes, there's this Kaduna Settlement Week that is coming up from 27th of July. I think it's coming up. So you are all invited. In fact, we have a road walk tomorrow. You can join us. So let me quickly share it with you so that you know that we are not playing with ADR and resolving disputes in Kaduna State out of court. We actually want parties to bring their matters for quick resolution, for parties to take ownership of their matters in resolving their own disputes. Sorry, let me do this quickly. Let me do this quickly. Meanwhile, if you have anything to add, you can add it. You can do so. This has been here. Oh my God. If you have anything to add. Why? Yes, with you. I'm looking for it. It's
I've actually shared it.
okay. Thank you, sir. Thank
I've
you so much.
shared the one for the road work.
Okay.
Yes, these are the schedules for the road work. The first road work was on 2nd of July. The second road work will be tomorrow, 9th of July. And
Hello, I can't hear you. Oh. Hello, can everyone hear me?
Yes, can
Yes,
hear
we
you.
can hear you. I can
Okay.
hear you.
I was not hearing Mr. Nanchang. Okay. All right. So, can we call it a day?
Yes, please.
All right. So, thank you so much. We appreciate your attendance. And like I said, we are open for more discussions. So, have a wonderful night. Enjoy your evening. Thanks so much.
All right,
Bye.
thank
Thank
you
you.
so
Bye
much.
bye.
I
Good
Bye.
night.
appreciate
Thank you
it.
so
Thank you
much.
so much.
So,
Thank you so
Bye.
much.
thank you. Thank you.
Be
Have a nice
grateful.
evening.
All right. Nice
Bye,
time.
ma.
Bye.